Hello, my name's David Winch. I'm a chartered accountant and a director of Bartfield's Forensic Accountants. And in this webinar, we're going to be talking about confiscation. And the title is Confiscation and Local Authorities. Actually, I'm really broadening it out a little bit to talk about confiscation where the CPS are not the prosecuting authority. Now that happens a lot where the local authority is doing it, but also in other circumstances. So let's have a look at the agenda. We'll have a quick introduction and then I will explain what I mean by confiscation cases dealt with by local authorities and others. And move on to the slightly unusual benefit issues which are likely to arise in these sort of cases. Discuss the general concept of prosecuting for profit and how does that fit in with confiscation in these non-CPS cases. And then that will bring us on to the recovery of prosecution costs. And prosecution costs can be a chunky and significant item in these cases. And then our usual roundup of how Bartfield's Forensic Accountants can help you. Okay, let's get started. We're going to look at topics in confiscation which cause some confusion and with a particular focus, as I've said, on cases in which the prosecutor is not the Crown Prosecution Service. We'll look at statute law and case law to help us out, and the cases, with one exception, which I'll highlight when we get there. The cases are on the Bailey website, so the judgments are available for free on there if you're not a subscriber to Westlaw or one of those others. There are a range of non-CPS prosecutors. Local authorities are the one that we most frequently see. But also some central government departments will prosecute not via the CPS. And then we have the non-government bodies and finally private prosecutors, because of course there's nothing to prevent a private individual in this country from prosecuting through the courts and acting as prosecutor. In each case, the common theme is that the investigating and prosecuting of offenders is not a core activity of this prosecutor. So that contrasts, of course, with the position where the police are investigating and the CPS are prosecuting. The prosecutor may therefore be less familiar with confiscation law and practice than the normal CPS prosecutors. And the nature of the criminal conduct may throw up some unusual benefit issues for the court to address. And it's more likely that a non-CPS prosecutor will apply for costs from the convicted defendant. And that can be a significant issue. One of the things about confiscation generally, of course, is that confiscation papers are generally not on the Crown Court document management system, the Crown Court DCS, which is perhaps a bit of a disadvantage when you're dealing with a confiscation. What sort of criminal conduct then might we be dealing with? Well, I've got a great long list of possibilities, which is by no means exhaustive. So the criminal conduct could be, for example, using trademarks on counterfeit goods, a trading standards issue. Could be adopting illegal high-pressure sales techniques. Again, we're talking here about consumer protection, which is an area that local authorities involve themselves in. Selling goods in breach of a license, such as selling cigarettes or alcohol to minors. Another local authority topic, buildings constructed or used in breach of planning or housing regulations. And we come across cases of breaches of an enforcement notice in that context. Lending money without a consumer credit license. I've seen confiscation in that situation as well. Marketing investments without authorization, not a local authority issue, but again, not one which might be handled by the CPS. Operating road haulage or passenger transport vehicles illegally. One of the largest cases that I dealt with a few years ago was a case called Boyle Transport, in which I was instructed by what was then VOSA and has now changed its name, but by the government agency which was required to manage and control the use of haulage vehicles, and took issue with Boyle Transport in that circumstance, and that moved on to confiscation and finished up in the Court of Appeal. Waste disposal without an appropriate permit or in breach of conditions. Again, we're looking at the Environment Agency, the Environment Department, who may be prosecuting somebody there, and there may be particular benefit issues arising in confiscation, which we'll talk about in a minute. Theft from the post office. The post office have their own investigators and will pursue employees for theft. Defrauding a pension scheme. We recently saw the pensions regulator taking confiscation proceedings against somebody who had been convicted of defrauding a pension scheme. So these are just some examples of the types of criminal conduct which might be prosecuted not via the CPS and might result in a confiscation. When we're dealing with these cases, the wording of the indictment is important. The charges on the indictment and the precise wording of them can be critical to the confiscation proceedings. Do they, for example, include a Schedule 2 criminal lifestyle offence? Schedule 2 offences include some money laundering offences, money laundering under Section 327 or 328, but actually money laundering contrary to Section 329, which is possession and use of criminal property, is not a Schedule 2 offence. Unauthorised use of a trademark, perhaps surprisingly, but that is there in Schedule 2. So that's an automatic criminal lifestyle of somebody who's been convicted of an offence, for example, under Section 92 of the Trademarks Act. Similarly, an article which infringes copyright. What about if we're talking about somebody who's been convicted of more than 3 offences from which the aggregate benefit obtained is at least £5,000? Here again, we've got a criminal lifestyle will be established by those convictions. Similarly, a single offence committed over at least 6 months from which a benefit obtained is at least £5,000. Again, that takes you straight into criminal lifestyle. And of course, if you're in criminal lifestyle, we're looking at the statutory assumptions. Where there is some ongoing offending, for example, breach of a planning enforcement notice, which we'll talk about a little bit more later, the wording of the charge can be critical as well. I say can be, not always is, but can be. Does the wording of the charge assert that there's been criminal conduct over a period of at least 6 months? Does it reflect the reality of the offending which is being alleged? You'll see why when we come on to talk about a few cases, why I mention those points. What about where you've got a business which is thought to be committing a criminal offence with each sale? You might have a single charge on the indictment covering a period of time, generally a period of at least 6 months. For example, a fraudulent trading charge. I've seen that used. Or you might have a series of specimen charges. Now, the problem with a series of specimen charges is that the court needs to be, from a prosecutor's point of view at least, needs to be put in a position where the sentencing for those charges is appropriate to the reality of the generality of the offending that's being alleged here. And similarly, if you're looking for confiscation, thinking about confiscation subsequently, then from a prosecutor's point of view, you will be wanting that series of specimen charges to be more than 3 and to allege a benefit, which you're going to succeed with in confiscation, you hope, a benefit of at least £5,000 in respect of those charges. Because if you achieve that, then you can proceed on the basis of a criminal lifestyle. And I've seen just recently a couple of cases where the confiscation proceedings have been put forward on the basis that the defendant has a criminal lifestyle, but actually nobody has really asked themselves the question, are the criminal lifestyle criteria of Section 75 satisfied in this case? And when you actually look at that in the detail, you find that they're not, and that a criminal lifestyle has been alleged, but actually the convictions do not support that. So from a prosecutor's point of view, you're definitely going to want to be careful with the indictment and with the wording of it to try and get the criminal lifestyle. Here's the case I was alluding to earlier, a case in which there was a planning enforcement notice which was breached, and it appeared that it had been breached over a continuous period of many years. But the charge on which the defendant was convicted was actually worded to refer to a breach on a single day. That was something of a mistake, because the confiscation order was limited to the rent arising in respect of that day only, which was agreed to be £58. Because this was then an offence which had been committed on one day, as far as the indictment was concerned, with a relatively trivial benefit, then the confiscation order, this was not a criminal lifestyle case because it didn't satisfy the conditions of Section 75. The confiscation order was for £58, whereas the local authority had intended to get a confiscation order well into 6 figures. But you can contrast that with the another more recent case, the London Borough of Harringay, and in that case, the Court of Appeal held that there was sufficient information on the indictment, and the defendant was fully aware of the case that he had to meet, and it was that he had breached the enforcement notice over a lengthy period. And therefore, although perhaps even in that case the indictment wasn't ideally worded, the court was prepared to accept that there was a chunky confiscation order that could be supported. Where a business has been carried on by a company, then the prosecutor needs to think, do I charge the company? Do I charge the directors? Do I charge both? And there are issues related to the veil of incorporation and so on, which we've covered in previous webinars, which are relevant to those sorts of decisions. But it's important from a prosecutor's point of view to get the indictment right, and from a defense lawyer's point of view to see what are the implications of the charges of which the client has actually been convicted. So yeah, do be aware of piercing the corporate veils issues, whether you are defendant or prosecutor. Piercing the corporate veil, of course, refers to the situation in which we, as it were, look through a limited company to its directors and owners. And again, we've covered that in a previous webinar, so I won't go into that now. let's talk about benefit. There can be some unusual benefit issues in these prosecutions. You're probably familiar with the case of Sumal, where a landlord was charged under Section 95 of the Housing Act 2004, and it was held on confiscation that actually the rent which he had received was not proceeds of the crime, was not suitable for confiscation as benefit. But contrast that with a slightly more recent case of Hussein, where the landlord actually had been charged under Section 179 of the Town and Country Planning Act, that's breach of an enforcement notice. And in that case, the Court of Appeal said that the logic of the Sumal case did not apply to Section 179 of the Town and Country Planning Act prosecution in the way that it applied to a Section 95 of the Housing Act prosecution. So again, whichever side of the fence you're on, you're going to want to check that the court is correctly dealing with the offence of which the defendant has actually been convicted. If a legitimate business is being prosecuted, then of course you have to be aware of the VAT issues that were covered in Harvey in the Supreme Court, which actually again was the case in which I was involved, where it was held in which that it would be disproportionate for output VAT accounted for to HM Revenue and Customs by the defendant to be recovered again in confiscation. So what that meant was that in terms of his benefit, when you were looking at the turnover and the gross receipts, you had to strip out of that the VAT which had been charged and collected from customers. Also, be aware of the argument about profit as opposed to turnover as being the benefit. In the case of sale, again, probably a case with which you're already familiar, the Court of Appeal held that what had happened here was that a legitimate contract had been obtained, legitimate goods and services had been supplied. The problem was that the contract had been obtained in an illegitimate way by bribing the purchasing manager of the customer. So it was said that it would be disproportionate to confiscate from Mr. Sale a sum representing the total turnover and receipts under that contract, because his business had supplied legitimately goods and services to the customer. So the customer had got that value, and therefore it would be disproportionate for Mr. Sale, the defendant, to have all of that confiscated from him. Instead, the Court of Appeal said the confiscation should be limited to the gross profit. But that contrasts with the case of Beasley. And in the case of Beasley, the business was one of selling counterfeit car accessories, wheel trims and so on, with a manufacturer's name and logo on that was not authorized by the trademark holder. And so the Court of Appeal said, well, in Beasley, the whole business was an illegitimate business. And in that case, the benefit was the turnover and not limited to the profits. So that's where the kind of dividing line can fall in terms of profit or gross receipts for confiscation and benefit. Don't allow confusion to arise between the loss to the victim and the benefit to the defendant. So on that point, the benefit to the defendant is what he obtains. The loss to the victim could be the whole value of what he gives. So if we've got an overcharging situation, for example, it could be said, well, the loss to the victim is the gross amount that he pays out. And that's appropriate to look at that for a sentencing point of view. But in terms of confiscation, we've got to look not at the loss to the victim, but the benefit to the defendant. And that is going to be perhaps based on the profit, if we come back to the sale situation. Money launderers, a bit different. A money launderer can find himself in a situation where he is mixing legitimate legitimate money with proceeds of crime in part of the laundering process. And in doing that, he may be obtaining the whole of that money, both the legitimate and the illegitimate, mixing it and laundering it. And his offence of laundering may be the laundering of the entire money, not just the proceeds of the predicate offence, as we refer to it. This can happen, for example, in tax fraud, where if somebody is defrauding VAT, their benefit might be the VAT that HMRC should have had and haven't. But if they then pass the value of goods plus VAT to a money launderer and get him to pass that through, let's say, his bank account, then the amount that he's passing through his bank account is not just the proceeds of the VAT which has been defrauded from HMRC, it's the whole value of the transactions. And in confiscation terms, the launderer's benefit may be, therefore, the whole of the value of the money that he passes through his bank account in the laundering operation, not simply the tax that has been evaded. Pecuniary advantage. We have in the legislation this provision that where a defendant obtains a pecuniary advantage, then he's deemed to obtain an amount equal to the value of that advantage. That seems like an attractive option for prosecutors, but it has to be handled with care because there are traps in there. First of all, the pecuniary advantage must be that of the individual defendant. There's a case there, Powell and Westwood, where a company, if you like, obtained a pecuniary advantage. It's arguable that perhaps the company didn't obtain it, but anyway, certainly the individual directors didn't obtain that pecuniary advantage because the liability that had been avoided, evaded, was not their personal liability. And therefore, when they were prosecuted and convicted, and the confiscation proceedings were put on the basis of a pecuniary advantage which had been obtained, that confiscation didn't succeed in the way that the prosecutor had hoped, because the advantage, which I think from memory was an advantage of clearing up a site where there'd been waste deposited, that advantage did not accrue personally to the directors, and therefore was not a benefit obtained by them for confiscation purposes. There was a very recent case, London Borough of Islington case, in which there was an enormously complicated argument put forward on the basis of pecuniary advantage. This was a housing overcrowding case, and the confiscation was put forward on the basis of what it would have cost to properly house all the people that were housed in the overcrowding housing that the landlord owned. Well, that was an expense which nobody ever actually suffered because it just didn't happen. They were not housed in appropriate housing of a proper standard. And so establishing the cost of what it might have cost to do that was a pretty theoretical exercise at the best of times. What the prosecution perhaps should have done was to simply say the benefit is the rent he's received from the illegal housing. That would have been straightforward. Instead, they went on this very complicated exercise of hypothetically what it might have cost him if he'd have housed the people in accommodation that didn't exist. and the Court of Appeal was not hugely impressed by that. Well, why do local authorities and others pursue confiscation? Do they do it for profit? Do they do it as an exercise to create revenue? Well, courts are aware, of course, of payments to prosecutors following successful confiscation proceedings. And a local authority does have power to prosecute, to act as a prosecutor in criminal proceedings under Section 222 of the Local Government Act of 1972. But that power is limited to where the local authority consider it expedient for the promotion or protection of the interests of the inhabitants of that area. And there have been criticisms of local authorities for perhaps going beyond that and going outside of their proper powers in prosecuting. A local authority cannot simply prosecute it as a business, if you like, as a commercial money-making exercise. And we see that in a case from 2017 where it was resolved by the DPP taking over the prosecution and the local authority ceasing to be the prosecutor in that case. And it looked to be a genuine fraud that required the authorities to prosecute them, but the authority that prosecuted should not have been the local authority. There's obviously a conflict of interest where the local authority is making money out of prosecution and confiscation. And there is a possible abuse of process argument where the local authority does that, particularly if it's done it as an alternative to other ways of achieving the required end in the public interest. So there was a case, the Knightland Foundation case in 2018, where the local authority could have pursued planning remedies to get work done which needed to be done. But instead of that, it actually preferred to prosecute with a view to obtaining a significant confiscation order. Again, the Court of Appeal was not impressed by that. That seemed to be not the local authority pursuing the proper aims of a local authority. It was instead pursuing raking in some money from confiscation proceedings. Talking of raking in money, prosecution costs, recovery of prosecution costs. There are a handful of leading cases on the recovery of prosecution costs from a convicted defendant. Neville and Gardner Merchant is from 1983 is one of the leading cases. Unfortunately, that case does not appear to be on Bailey. That's the only one that I'm mentioning today that doesn't appear to be on Bailey. But the more recent case involving Associated Octal is on Bailey, and again, yet more recent case there from 2017. Also, do have regard to the criminal procedure rules. One of my favourite QCs keeps reminding me that we really should talk about the criminal procedure rules as well as the statute. Part 45 of the criminal procedure rules and the associated practice direction deal with recovery of prosecution costs. And the costs that are recovered are actually specified by the criminal court. There isn't, in these circumstances, criminal court prosecutions, there isn't a procedure for what is sometimes called taxation for the assessment of costs. It's pretty much put your schedule in front of the judge, he'll have a look, agree it or not, job done. But there are some general principles that we can see in relation to recovery of prosecution costs. First of all, the order to pay costs should not exceed the sum which it is reasonable to expect the defendant to be able to pay, having regard to his means and also to any fines or other financial orders that might be involved in the case. And of course, where there's confiscation, it may well be that the confiscation proceedings take all his available amount and he's not able to pay any prosecution costs. The purpose of a costs order, we must remember, is to compensate the prosecution for the costs it has incurred. It's not intended to be an additional fine, an additional penalty for the defendant. The purpose is, as I say, not to penalise the defendant, but to compensate the prosecutor for the costs he's incurred. And so the order should not exceed the costs which the prosecution have reasonably and actually incurred. Those costs are not limited to the costs of the trial or even of the prosecution in that sense of the legal work in putting the case together for trial. They can include the costs of the investigation which is involved prior to the trial. And of course, it might be that the investigation covers some offences and conclusion is that there isn't sufficient evidence to pursue those particular elements to a charge and to trial. But the investigation has to happen in order to reach that conclusion. So those costs of investigating offences which ultimately don't finish up in the indictment, those costs are recoverable as well from the convicted defendant. Where there's more than one defendant, then generally what the court would look for is a proportion of the costs applicable to him. So if you've got 5 convicted defendants, each of whom is a millionaire, each of whom is well able to pay prosecution costs, then it would be sensible, wouldn't it, to split the prosecution costs 1/5 to each of the 5 defendants. But what about where you've got 5 convicted defendants, 4 of whom are stony broke and have no assets, and the 5th is a millionaire? Is his costs order to be limited to 1/5 of the total costs? Well, the short answer is no. What the court will then do is to look at what it would have cost to prosecute just him. And he can be liable for a costs order in relation to a proportion of the costs which would have applied to prosecuting just him, even if that means the other 4 defendants pay no costs at all because they have no funds. In awarding costs, the court should take account of factors including the time spent on the case, the conduct of the parties, the complexity of the matter, and the skill, effort, and specialised knowledge involved. And there are other factors as well. That's not the exhaustive list. Do note in the middle of there, we said the conduct of the parties. So if you've got a defendant who goes out of his way to create problems for the prosecution, then there is the risk that if the prosecution get an order for costs, he may be particularly hit in relation to additional costs which have been incurred because of him being particularly awkward. I'm not saying here that somebody's going to be hit for more costs, let's say, because they plead not guilty, as opposed to somebody who pleads guilty. They're not going to be hit for more costs for that reason, as a sort of slap in the face for pleading not guilty. But what is going to happen is that because they have pleaded not guilty, there will have been a trial, and therefore the costs will be greater. If a person pleads guilty and there is no trial, then obviously that will reduce the prosecution costs. And all of this stems from Section 18 of the Prosecution of Offences Act 1985, which says the costs order should be just and reasonable. Of course, what is just and reasonable ultimately is a decision for the court. Okay, we've gone slightly over our time. I'm sorry for that, but just to remind you, Bartfield's Forensic Accountants remains fully staffed. We undertake legally aided and privately funded criminal and civil forensic accountancy work. we've been very fortunate in that because we use technology so much, it's been relatively easy for us to conduct the bulk of our work remotely using up-to-date and secure IT facilities. These days we're in the office a little bit more than we were a couple of months ago, but of course things are still not yet fully back to normal. We remain, however, readily contactable by phone, by email, and online, and we're doing Zoom calls and Teams meetings and all this sort of stuff. And our recently updated website is full of useful information. There are over 100 blog articles on there with detailed technical information that you may find of use. Of course, it's fully searchable, and of course, it's on Google and so on and so on. For this topic, if you look on our insights pages, you will find the blogs, and also you will find the recordings of the webinars. The recording of this webinar will be up in a few days' time. The recordings of previous webinars are there and accessible anytime. If you've got questions, the best thing to do probably is to email them in, and there's my email address. I will happily answer any questions you have arising out of this webinar and help you in any way that I can. Thank you very much for your time once again, and we will see you again in 2 weeks. Thank you.